So, you think you figured out a way to design around that patent, do you? Not so fast. My name is Steve Hansen. I've been a practicing patent attorney for over 25 years. Not only do I write patents, but I tear apart other people's patents in litigation. Hey, if you like this content, please do me a favor and like, follow, and share. This is the third of a three-part video series on the dangers of designing around a patent. This one concerns the doctrine of equivalence. So, one place you can get into trouble when you're designing around a patent is if you're unaware of the doctrine of equivalence. The doctrine of equivalence holds that if you are literally missing one element of a claim, you may still infringe if you have something else that could be deemed an equivalent of that element that you are literally missing. So let's say you have a patent claim that says A, B, and C. You say, I'm going to pull out B and I'm going to use D instead. If D is considered to be substantially similar to B, then you may still infringe that patent claim. And that is called the doctrine of equivalence. The law of the doctrine of equivalence is complicated, and you can really get yourself into trouble if you try to engage in self-help, just like with claim construction. If you have a real infringement issue that is a concern to your business, I would definitely seek the advice of a competent patent attorney. With the doctrine of equivalence, it's complicated, first of all, because there's limitations on it. And the limitations concern what was said to the patent office while the patent was being prosecuted. If the claim element at issue was one that was added to distinguish the prior art, or was one that was relied on in an argument to distinguish the prior art, that may limit or foreclose entirely the application of the doctrine of equivalence. That situation is what we refer to as prosecution history estoppel, and it does take some experience to be able to review a file history in view of the law of prosecution history estoppel to see if it applies. Assuming that it does not apply, then the issue is whether the element you have used instead of the claim element is substantially similar to it. There is a test that's often applied, although it's not the exclusive test, called the function way result test, which asks if the equivalent and the thing it's equivalent to in the patent claim perform the same function in the same way to achieve the same result, basically. And that's one way that you can assess equivalence. But the key here is that you should not just assume because you have made some kind of change that you are out of the woods. You have to account for the doctrine of equivalence. So if you are trying to design around, please talk to someone who knows this area of the law. I hope that helps to keep you out of trouble, and I hope to see you here soon.